that is opportunities in stressed asset and funding of stressed asset along with the resolution plan. We have with us the chairperson of the Nagpur branch, CA Jiten Saglani sir. I just welcome sir for his brief remark. Jiten sir, over to you.
So good evening, one and all present here. It's a very nice weather outside, and we are all here to actually listen from CA Prasad Dharap, who is the speaker of today's session, which is happening on funding of stress assets, basically on stress assets and its funding as well as resolution. And I welcome you all to this third session in the series of IBC, which is actually organized by Committee of Insolvency and Bankruptcy Code of ICI and being hosted by the Nagpur branch along with the Goa branch. Friends, I think learning should continue. This particular session, wherein this is the third session of the entire series, will be having actually insight on what is stress asset, funding of stress asset is done, and what is the I think we have the speaker in the form of CA Prasad Dharap ji. Sir had been so kind and nice because he had a session earlier as well, like IBC committee, and now he is having a session with the Nagpur branch. So back-to-back sessions for him as well. But I think he's so nice and kind that he accepted our invitation and is here today. So that shows the commitment of members. Thank you so much, sir. Friends, we have past chairmen also in the committee in the meeting right now. So I welcome all the past chairmen along with you all. And I believe that this session will be adding a lot of value to each one of us. And I also request you all to please stay connected with the Nagpur branch, because we have one more session in this series happening on 18th of June, which is on liquidation, which is being hosted by Nagpur branch again with Goa branch. And this session would be taken care of by C. Atul Rajwadkar ji. So he's a speaker in the fourth session, which will be on liquidation. Friends, we have not many sessions planned in the future events, like we have on 13th session on MSME, which is basically on incentive schemes of the state government for various projects. And beyond that, we also have other sessions lined up next week, which is on 17th and 18th. So do stay tuned with the Nagpur branch for its future events as well. And we will all have a good learning and good insight through this session. So happy learning to one and all, and over to you, Trupti ma'am, once again.
Thank you so much, Chairperson sir. Before going further, I'll take the opportunity to introduce the Prasad Dharap sir, who is the speaker of the session. He's a practicing chartered accountant at Dharap, Kolhatkar and Company, and also a insolvency professional registered with IBBI. He has done his post qualification diploma in information system audit conducted by ICAI, and also obtained ACCA diploma in international financial reporting conducted by ACCA London. He has handled in person and as a support service to other various cases as insolvency professional in various roles like IRP, RP, and liquidator. He has been a guest faculty at NADT, that is National Academy of Direct Taxes, and has published various articles and has contributed various articles to various newspapers. And if I start briefing down each and every aspect of this, it will take another 20-30 minutes. So I won't take much of your time and won't be huddled in between the speaker and the session. I'll request Prasad Dharap sir to kindly take over the session. And request each and everyone to please put your hands together and welcome Prasad Dharap sir. Over to you, Prasad sir.
Yeah. Thank you, madam, for such nice introduction. I also thank Chairman of Nagpur branch, CA Jiten Sanglani, and all the managing committee members, even our RCM, Abhijit Kelkar, who has been very much instrumental in having such a series for IBC on each Saturday, this being the third Saturday. Till now, you have understood about the CIRP process, which is an important process. Even you have understood about the fast track CIRP process. Today, the topic which has been allotted to me by the branch is opportunities in stressed asset and funding of stressed asset, along with the resolution plan. All these three topics basically go hand in hand. And if you see that these topics basically are not directly from the code and regulation as such. It is a general topic. Even a non-IP person, a member, can definitely work out on these areas. So friends, even if you are not insolvency professional, that is what I have been telling everyone, that even if you are not practicing directly and not sitting in the main seat, there are several areas in which you can find opportunities in your profession, and making and preparation of resolution plan is one of them. So for that, you need to know the basic things which are there to be complied as per the code and the regulation. So first, we will try to see what are the stressed assets. So before going into stressed asset, I would like to go through a little bit of background, wherein the India's regulatory framework to deal with stressed assets has started with the following broad developments. Mainly, many of you must be remembering that there was an act called SICA, Sikh Industries Companies Special Provision Act 1985, which gave birth to BIFR, Board of Industrial and Financial Reconstruction, having a very wide powers as conferred in the SICA. BIFR dealt with issues like revival and rehabilitation on Sikh companies, winding up of Sikh companies, institutional finance to Sikh companies, amalgamation of companies, etc. So basically, BIFR was a quasi-judicial body, but somehow SICA, that is Sikh Industrial Companies Act, failed due to its applicability only to the industrial undertaking, and even the moratorium that was granted was often misused. After that came the Recovery of Debt Due to Banks and Financial Institution Act 1993. Then came the SURFACE 2002, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. And lastly, and at present, the thing in the market is Insolvency and Bankruptcy Code 2016. Now, all the earlier things means after learning from failures of these legal provisions of these acts, Insolvency and Bankruptcy Code was introduced. So basically, you should try to understand that as such, it is not an act. It is a code. Means it is a compilation of various things taken from various acts, and a code is prepared. just like the Indian Penal Code, IPC. Similarly, this is IBC. It is a code that should be first understood. Now, what is a stressed asset? Stressed asset basically, it is NPA plus written offs and the restructured loans. Even SMA before a period of 90 days can be termed as stressed asset. So once you know that what is stressed asset, we can definitely deal with stressed asset. But for that, we need to know that how it can be dealt with. So what has changed from the earlier scenario? So IBC is the game changer. IBC has given stressed assets resolution a legal structure, definite procedures, and has provided a level playing field for domestic as well as foreign investors. It has established well-defined timelines for the resolution of distressed companies. It denotes a paradigm shift in which creditors take control of the assets of the defaulting debtors. Now, what used to happen earlier, that companies were run by the promoters, directors, and the lenders, that is the financial institutions, were technically helpless under the earlier laws like the SICA and BIFR, which I was referring to. Why? Because the control of the entity and the entire process remained with the corporate debtor, means the promoter or the director. And they used to take the financial creditor, that is the banks particularly, on the ride. Why? Because there were lot many things that were available to them for stretching and testing the patience of the financial institutions. So all these things are now stands removed, and now IBC gives the control of the company in the hands of financial creditor. So issues that were there with the earlier regulatory framework was huge piling of NPAs. Creditors were required to wait for years to recover their dues. Now, under IBC, there is a definite timeline under which every person who is connected with the ecosystem has to perform his duty within that timeline. Of course, there are certain exceptions wherein the timelines are stretched, but still they are not stretched to such an extent as was possible earlier. Now, earlier the debtors were in control. So when I mean to say that now the creditors are in control, so under this new scenario, after admission, see, basically, I will just give you an example of a human being who is ill, I can say, or who is who needs to be taken to a hospital. So similarly, the unit which is stressed is taken under the corporate insolvency resolution process. And if the basic criteria is that the stress should be removed and the company should be run by the persons who are capable of running the business. And If there is no resolution that is coming, then and then only the company will be taken to liquidation. That is the last resort. So here, from the day one, once the COC is appointed, the banks or the financial institution who has granted the loan to the company becomes the decision maker in the COC. And that is why we are saying that creditors are now in control and debtors, that is the directors or the promoters, are eligible to attend the meeting of COC, but they don't have any right of taking any decision. They don't have any right of voting. Even coming back to the earlier regulatory framework, it was never a time-bound process. Promoters had a scope to delay the process and frustrate the creditor. Now, under the new regulatory framework, that is the Insolvency and Bankruptcy Code 2016, it is a time-bound process. Creditors are in control of the entire process. Fragmentation in corporate insolvency framework stands removed. Why? Because now there is only one law for resolving these issues. There is no question of any fragmentation or earlier laws stands withdrawn, and credit will flow more freely and will increase faith and confidence of the creditor. What is important is that the money which is stuck up for a bank will get released in a definite period, and that can be more effectively employed elsewhere in the economy. Now, the Economic Survey 2021, what does it say? That almost 1,500 companies have either been liquidated or taken over under the IBC, and another almost 1,800 companies are undergoing the process. The average time taken for resolution of companies is 441 days as opposed to 328 days for liquidation. The standard statutory upper limit is 330 days. So as I told you earlier, that we are still not able to achieve the mandatory timeline which is given in the code. As you can see, that 441 days are required for resolution and 328 days are taken for liquidation. That is the average. Thus, the value of asset is protected because, as you may note, that if too much of time is spent in the legal process, then the value of asset which is to be utilized or resolved or liquidated, that will certainly have an impact in terms of value with passage of time. So value of the asset under the new code is protected, and earlier there was lack of consensus among the lender, delay in the court processes, and fear of commercial decision making in the largely government-owned bank, and therefore it created a great nuisance. Because many of us might have noted that decision making was a main hurdle in the banking scenario. Now this hurdle stands removed. Why? Because they have to take a decision within the stipulated time. So now the COC or the banks are also under obligation to take the decision within that timeline. See, whosoever wants to stop me at any place or can definitely stop and question. At the end also we can have some question answers, but in between I don't mind if somebody is talking and getting the query resolved. So what is the gross NPA scenario? As financial creditors start recognizing more non-performing loans, it leads to more distress debt opportunities for investors, including buying these NPAs. The gross non-performing assets ratio, according to RBI Financial Stability Report 2021, is likely to increase from 7.48% in March 21 to 9.8% by March 22 under the baseline scenario and 11.22 under a severe stress scenario. Simply speaking means about this much percent of the loans will be turning bad, the bottom line and the top line, baseline and the severe stress scenario. Now, what are the government measures that a government is taking? Government front loading of investment and spending will likely to encourage the turnaround in the economy. That we are seeing that government is spending a lot of money in infrastructure and other projects. So ultimately, that accelerates the economy in general. Even recent formation of National Asset Reconstruction Company eliminates one of the major headaches of aggregating loans from multiple lenders. So this is also a very much welcome step. RBI has effectively opened up the trading of stressed loans to other regulated players in the market, which was earlier in the domain of ARC. Now that AIF and others are also permitted, we are going to see that later on. Thus, India offers a unique opportunity for yield-hungry investors at one end of the spectrum and the high-growth capital risk investors at the other end of the spectrum. Now, if we look at the global players and domestic investors, global players who are willing are peeping from outside the fence, waiting to see how the new framework play out. Means they have some fear in the mind. Now, after passage of 5 years, almost they have also started participating. But domestic players in the meantime have started working actively and acquiring the assets at a discounted prices. Certain reforms like growth of specialized financial intermediaries like ARCs and AIFs have made it increasingly feasible for sophisticated investors to bring in resources for reconstruction. Stressed assets as an investment class are set to take off and are a rich source of value buy investment opportunities for foreign institutional investors looking to invest in India. Now, obviously, the question arises as to why to invest in the stressed asset. Now, if a company is a good company, and if you are getting the company at a distressed value, then naturally the returns, that is IRR, will be high. And there is a potential to earn very high returns. Like if you get assets worth rupees, say 30 crores, or a sum of 8 crores. So naturally, you will be preparing your financials based on 8 crores. So that is what is happening in IBC, that the fall in value of the assets of the company is being encashed, and accordingly the resolution plans are worked out. There is every chance of high returns. Liquidity, because of such a code existing in the market, NPA recovery is better for the banks, and therefore they will have more liquidity to pump in the money in the market. Even in case of cost-effective expansion, distressed companies allows for a strategic way for vertical and horizontal integration, because you are going to get the company at a discounted price. 6 points to consider while investing in the distressed asset. You should see the risk and the reward, low correlation with the traditional asset class, then the legal challenges. As I tell you that certainly there are some legal challenges in one of our industries in our region, a distillery unit which was acquired by one of the resolution applicant. Everything went on smoothly. The plan was permitted, was approved rather by the adjudicating authority, that is NCLT. But the license of the distillery was not transferred, and the excise department objected, and the case was held in the court for about 1.5 to 2 years. So when we are giving a proposal, such type of legal challenges may come in the form of contingencies, and since this is a new field, it is new for each and every department of the government. So there is a lot of resistance as well as confusion in the government departments. Fourth point is partnering with experts. Partnering with expert means while you are investing in a new business of the stressed asset, you need to have experts of that particular field. Like in the present case, when I am talking about the distillery, and if you don't have any past experience, it is necessary that you should have experts of that field along with you. Even though IBC does not allow the promoters to continue, many times help of the earlier promoter will be required to run the new business taken over under IBC. And last is the robust incentive framework. Means what type of incentives you are getting, that has to also to be studied and seen. So basically the winds of change are blowing across the Indian investment management sector, buoyed by easier regulation and tax clarity for alternative investment funds, investment advisory and portfolio management service, and greater availability of domestic capital. TAR fund managers are turning entrepreneurs. So these are very helpful. The phenomena of the owner fund manager is gathering momentum, and I think they should change the face of Indian fund management industry. So That is about the stressed asset. As far as the next topic of funding is concerned, funding of stressed asset with the introduction of IBC, now even many banks have understood that it is better to fund a resolution applicant who is buying the stressed asset. So even the banks are ready to fund such type of proposals. Apart from that, top factors driving fund managers to start their own outfits is evolving of AIF regulation and tax clarity. Setting up of onshore fund in India became a lot easier after SEBI introduced the AIF regulations. Launching onshore hedge funds became possible for the first time. Earlier, offshore funds were there, but now SEBI has permitted to launch the onshore funds in India. The figures of registered AIF has gone up from 235 in 2016 to about 946 as of now. So such a large number of increase in the registered AIFs. Then rise of the domestic limited partner. There are larger pools of domestic capital available in India today, and the investors are looking for differentiated strategies that can help them maximize their return. Alternative investments are becoming popular among this set. Next is the increasing momentum of the alternatives as an asset class. Now, if you look at the figures, investments made by AIF surpassed 24,800 crores at the end of the second quarter of 2016-17, as against 11,255 crores at the end of September 15. So there was a significant rise between these 2 years. But if we compare it with the current figure of March 22, this investment has reached to a level of 2,84,058 crores. So naturally, this is the impact of IBC, which has channelized the money and increased the investments to such a great extent. A new breed of fund managers eager to plug the gaps. India has a wider pool of experienced fund managers across asset classes today. These fund managers have the confidence, expertise, as well as strong network of relationships to fly solo. So these are all the advantages. Now, the rise of owner fund managers will have significant implications for wealthy Indian investors. These includes availability of differentiated and tailored investment strategies, which has already come up in the market. Greater choice for both investors and fund managers. Alignment of interests. Negotiated fees. And greater stability and lock-ins with the star managers. So the changing regulatory and taxation climate in India is finally beginning to foster a nurturing environment for newbie investment funds. Investment professionals with 10 to 12 years experience of delivering great returns are taking advantage of these developments to launch focused investment vehicle. While a few hiccups related to support infrastructure, taxation, and fundraising remain, the stage has been set for deeper activity in the sector, including in the alternatives space. This will enable investors to further diversify their portfolio, choose from larger range of investment opportunity, as well as demand more personalized services. I think this is sufficient reason for both investors and fund managers to be excited. So basically, stressed assets and the funding of stressed asset. But apart from that, the next topic of resolution plan, which is the main portion wherein we can have this stressed asset and then we can think of funding of stressed asset. So I would like to now deal upon what is the resolution plan. So a resolution plan is a plan proposed by the resolution applicant for insolvency resolution of the corporate debtor, which may include provisions for restructuring of the corporate debtor, including by way of merger, amalgamation, and demerger. So it is basically a plan given by the resolution applicant to resolve the stress of the corporate debtor. Who is the resolution applicant? A resolution applicant is a person who submits the resolution plan to a resolution professional and is not disqualified under section 29A of the code. Now, 29A, I am going to deal with that section later on. That itself is a very big section. But what we need to understand at present is resolution applicant can be a person who is not disqualified under section 29A. Similarly, the creditors or the promoters of the corporate debtor can become resolution applicants and submit a resolution plan. So basically, even the creditors of the corporate debtor can become resolution applicant and submit a resolution plan. So if in a COC we have an ARC or an NBFC, so they can also submit a resolution plan and take over the company. It has not been discouraged. Now let us see who is not or cannot be a resolution applicant. The section defines that a person will not be able to submit a resolution plan if that person or any other persons acting jointly with that person. So now this definition is a typical definition. If you even are related with the person who is not eligible, then you also becomes ineligible to submit a resolution plan. But particularly an undischarged insolvent, a willful defaulter, these are, I am talking about the persons who cannot be a resolution applicant. Next is having an account of a corporate debtor at the time of submitting the insolvency resolution plan, management of such person or whom such person is promoter categorized as NPA under the guideline of RBI, and that 1 year has elapsed since such classification until the date of initiation of CRP of the corporate debtor. So what does this mean? That if you are an NPA and if a period of 1 year has lapsed, then you are disqualified from becoming a resolution applicant. Next is, has been convicted for any offense punishable with imprisonment, is disqualified to act as a director under the Companies Act. So because of these restrictions, problems are coming to the existing promoters to take over their companies. Similarly, next disqualification, the resolution applicant who cannot be a resolution applicant is the person who is prohibited by SEBI from trading in securities or accessing the securities market. Next is, has been a promoter or in the management or control of a corporate debtor for which an order of PUFE transactions has been passed by adjudicating authority. Now, PUFE means preferential transactions are there. If some preferential transactions are made and you are found guilty, then undervalued transactions, if they are there in the company, then fraudulent transactions and extortionate transactions. So if you are convicted of these PUFE transactions, then also it brings an ineligibility for becoming a resolution applicant. And lastly, has any other disability defined in the code. Now we will see what are the main ingredients of a resolution plan. Section 30 of IBC spells out the necessary ingredients for a resolution plan. The first one is, the plan should not be in contravention to any of the provisions of the law for the time being in force. So naturally, if there are certain things which are governed by other laws, so there cannot be a contravention with the other laws. Next is, in case the resolution applicant envisages any relief or concession from any state central authority, it should be ensured that such relief or concessions are permissible under the provisions of the law in force. So what does these provisions indicate is, you cannot ask for certain things which are not permitted under the law, under any other law. Next is Regulation 37 of the CIRP regulations lay down various measures like obtaining clearances or permissions, etc. from the Forest or Environment Department that should be addressed in the resolution plan. So those type of measures you have to take as a resolution applicant. Next is, if a resolution plan envisages significant acquisition of shares, then the necessary compliance with the regulator, it is SEBI, has to be taken. Now, you can note that this is in contrast with the provisions as contained in the SICA, which permitted the BIFR to grant exemption from complying with the SEBI takeover norms. Earlier, these things were possible, but now it is not possible under the new regime. And the next is, if the proposal requires merger or amalgamation, it has to be ensured that such merger does not contravene the provisions of the Competition Act. Thus, at times, permission may be required to be obtained from Competition Commission of India, CCI. Now, Regulation 38 covers the mandatory conditions of the resolution plan. Plan shall identify the source of funds. See, it is essential to explain that from where you are going to induct the money in resolving the stress unit. That is the mandatory content. Next is, plan should provide for insolvency resolution process cost and should ensure that it should be paid in priority over other creditors. So earlier you might have understood that there is a cost called insolvency resolution process cost, and it enjoys priority over while making the payment. So that should be ensured and mentioned in the resolution plan. Next is operational creditor. It should be ensured that the liquidation value in priority should be paid prior to any financial creditor. So what the regulation says that in the event that the company would have got liquidated, whatever value that might have been received by the operational creditor. So friends, here, particularly in many cases, under section 53 of the code, that is under that liquidation, we have seen that the operational creditors are going to get nothing. So, but still, what practice that is being followed is pay operational creditor 1% or 5% if you are giving it by way of a resolution plan. So that is also one of the mandatory contents. And the thing is, if you don't follow this, if you don't provide anything for the operational creditor, there is likelihood that your plan will get rejected. So these mandatory contents are to be followed. Payment made to the dissenting financial creditor. Again, he should be ensured the liquidation value. Dissenting financial creditor means, in one of my case where there were 4 or 5 bankers and another banker who have given a clean loan to the company. So they didn't had any security. So they were not in the class of secured financial creditor, but they were classified as unsecured financial creditors. So naturally, while voting for a resolution plan, they have voted negatively. These are the creditors who have dissented. So the code says that for all the dissenting financial creditors, the liquidation value should be ensured in the resolution plan. Now the next question is, whom to submit the resolution plan. Prior to that, I will just tell you in brief that the first 30 days, the COC is constituted, and between 75 to 90 days, expression of interest Form G is published by the RP in order that whosoever wants to participate in the resolution of the company by way of submitting the resolution plan, they will be making an application, and thereby they will be in a position to submit the resolution plan. I will explain it further in detail. So we will see as to whom the plan should be submitted. IBC section 30 subsection 1 states that a resolution applicant may submit a resolution plan to the resolution professional prepared on the basis of information memorandum. Earlier speaker might have covered that what is the information memorandum. It gives the entire details of the failed unit, that is the corporate debtor, and based on that, the resolution applicant, after scrutinizing that information, visiting the site, he decides whether to go for the resolution. He conducts his own due diligence and works out the value to be offered. So this is, sorry, I missed it somewhere. So information memorandum is an important document, and the resolution plan is to be submitted to the resolution professional. The resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for payment of insolvency resolution process cost in priority to repayment of other debts of the corporate debtor. Similarly, provides for the repayment of debts of the operational creditors, provide for the management of affairs of the CD after the approval of resolution plan. That means that he has to address the issue as to how the corporate debtors' affairs will be carried out once the approval is granted by the adjudicating authority. The implementation and supervision of the resolution plan. This is also to be addressed, that how the plan is going to be implemented, how the plan is to be supervised. Now, for this particularly, once the approval of the adjudicating authority is received, within the plan itself, a monitoring committee has to be stipulated, and monitoring committee will be approved by the adjudicating authority, that is NCLT, and that monitoring committee, I had been a part of one of the monitoring committee of Bank of Baroda, in which we tried and verified that whatever has been said in the resolution plan, whether that was properly followed or not before completing the CIRP process. So for that reason, you need to define the implementation and supervision of the resolution plan. Next is, it does not contravene any of the provisions of the law for the time being in force that we have discussed, conforms to such other requirement as may be specified by the board. then RP has to ensure that the resolution plan is accompanied with the affidavit that resolution applicant is eligible under section 29A of the code. This is a very typical and ticklish issue. Oh, we are taking an affidavit and undertaking. As a RP, it is our duty. In one of my case, I came across a situation where the resolution applicant was a willful defaulter declared by the other bank, and I took it on record because this field of IBC is full of litigation. The corporate debtor will be fighting with the RP. At times, the COC members may be entering into litigations with the RP. RP being the center, at the center, he has to take care of all the stakeholders whose interest will get affected. So he has to ensure that the resolution plan and resolution applicant does not disqualify in 29A. Next is, if the resolution plan does not comply with the regulation, it will be rejected. So that is also important, that when I have, because see, ultimately the objective is, once as an RP, you are putting the resolution plan in front of the COC, that means it is presumed that RP must have taken care of all the necessary legal requirements and ensured that it does not contravene with any of the provisions. So now here the responsibility of RP comes. So in one of my case, I have rejected the resolution plan, but in that case, I have to mention, I have to clearly tell them that why I am rejecting the resolution plan. So here the resolution plan also can be rejected. The resolution professional shall present to committee of creditors for its approval such resolution plans which confirm the conditions in section 30 subsection 2 of the IPC as well as relevant CIRP regulations. So that is what I was telling, that if the resolution plan complies with all the necessary legal conditions contained in the code as well as the regulations, then and then only that RP is supposed to put the resolution plan for consideration in front of the COC and for its approval. Once the resolution plan is submitted, the COC shall evaluate the resolution plans received as per the evaluation matrix. Yes, this evaluation matrix also might be the earlier speaker might have covered. But still, if some of you need to understand, evaluation matrix, information memorandum, evaluation matrix, and RFRP documents are the documents which are required to be prepared in consultation with COC, and evaluation matrix is nothing but the marks to be allotted on the basis of which the evaluation will be made for the resolution plans submitted. If suppose say 4 or 5 resolution plans are received, then the resolution applicant needs to know before giving the resolution plan that this will be your evaluation sheet. We will be, even the marks will be mentioned, that on the basis, means it is an open thing. It is not the case that they do not know. Resolution applicant is aware that these are the criteria on the basis of which we are going to get the marks. So this is the evaluation matrix. So once the resolution plan is submitted, the COC shall evaluate the resolution plan received as per the evaluation matrix to identify the best resolution plan and approve it with modifications as it deems fit. Regulation 39(3) of the CIRP regulation. Next question, whether a resolution applicant or his representative can attend the COC meeting. Yes. The resolution applicant or his representative.
मैं ट्यूसडे को भैया मैं 12 to 1:30 है बट मंडे को क्या सिनेरियो सब देखने के लिए मैं अलॉट नहीं कर पाऊंगा.
Excuse me, somebody's voice is coming. Please put it on mute. Unless and until you have some question, that is okay. But please don't talk with each other. So whether a resolution plan applicant and representative can attend the COC meeting, yes. The resolution, so he can attend the meeting in which the resolution plan of the application is to be considered, because he has nothing to do with the other matters. Means even when while the COC meeting is going on, let us say there are 7-8 items on agenda. So normally what we do is, if the agenda for acceptance of resolution plan or discussion on resolution plan is on 4th item, so the resolution applicant or his representative is asked to wait outside the meeting hall, and only when the turn comes in the agenda, they are called in, and immediately after the discussion is over, they are requested to again go out of the meeting. So they can come in the meeting only for the limited purpose wherein they should attend and listen to what is happening. So they are eligible to attend the COC meeting, provided that the resolution applicant shall not have a right to vote at the meeting of committee of creditors unless such resolution applicant is also a financial creditor. Like as I told you earlier, that resolution applicant can be a NBFC, it can be an ARC who may be interested in giving or taking over the company. So that is permitted. And in that case, naturally, they are required to vote for their plan given by them only. That is allowed. Whether negotiation can take place between COC and resolution applicant. See, basically, maximization of the stakeholders' value being the basic objective of the code, nothing stops COC and resolution applicant to negotiate and renegotiate the value and other terms conditions of the plan before the plan is being accepted or rejected by the COC. In one of my case, where I was representing the resolution applicant with a nationalized bank, there were about 3 to 4 such meetings wherein the price was the only thing, and my client used to increase it marginally, and the COC was not satisfied. So ultimately, the thing went up to the 4th meeting, where their expectation and the offer given by the resolution applicant met each other. And then after the 4th meeting, they agreed the approved the resolution plan. Even in another case where there were about 4-5 banks, the COC was negotiating. At that time, 3-4 resolution plans were received, and my plan was at the bottom, at the last number. So based on the evaluation metrics, it was free for me to improve my offer and get it improved until I stand at the first number. So accordingly, changes were made and my plan appeared on the first number and it was accepted by COC. So negotiations are possible. Next is who grants approval to the resolution plan. The COC may approve a resolution plan by a vote of not less than 66% of the voting share of the financial creditor. So this is the class of creditors and in which 66% minimum vote is required for approval or even rejection. So approval or rejection of the plan is at the discretion of COC. RP and adjudicating authority cannot interfere in this decision taken by COC if rejected. So adjudicating authority is left with no other option other than passing a liquidation order. So a case has been decided by Supreme Court telling the NCLT and NCLAT that it is the commercial wisdom of the COC to approve or reject a resolution plan. You cannot trespass or enter into their area of taking the decision. Here the COC decision is the last. What Supreme Court has guided that the adjudicating authority has a very limited thing to be seen in the what has been mentioned in section 30 subsection 2, that it complies with all the legal requirements and it is not in contravention with anything or inconsistent with any other act or even for the code. So there should not be legal inconsistency. That is the limited thing which is to be reviewed. Otherwise, adjudicating authority has to grant approval to the plan approved by the COC. Who will submit the plan to adjudicating authority? So now, till now, you might have understood that a resolution plan is to be submitted by the resolution applicant to the resolution professional, RP. RP will place it before COC. COC will give the approval. Once the approval of COC is in place, again it is the RP who is required to make a petition to the bench for approval of resolution plan. So it is the RP who will submit the plan to the adjudicating authority, that is NCLT. The resolution plan so approved shall be binding on the corporate debtor and its employees, members, creditors, guarantors, and other stakeholders involved in the resolution plan. There is one section 31 subsection 1 of the code which says, now subsequently upon approval of the resolution plan, there is no legal remedy available to the employees, other creditors, guarantors. It is binding. Can a resolution plan approved by COC be withdrawn? Basically, there is no provision in the code which permits withdrawal of such resolution plan. Basically, this need has come in the recent couple of years, wherein the entire economy was stopped due to COVID since the last 2 years, and the resolution plans which were there in the pipeline, which were approved by COC, the resolution applicant pleaded in front of the bench that now the economic scenario has totally changed and he needs to rework. So that was not allowed in many cases. So there is no provision to withdraw the plan. It is compulsory. Next, what should be the table of contents of typical resolution plan? So this is very interesting. So like friends, earlier we used to make the financial projections or the project report where the technical and financial feasibility used to be studied by the banks before funding. Similarly, here we have to prepare a detailed resolution plan. I will just tell you what are the normal contents. So first one is the definition and interpretation of the terms that are used in the resolution plan. Just a moment, there is some technical issue at my end. I will try to resolve it. Please be online. You are able to see my sharing?
No, sir. As
Ah.
of now, it's
Yeah.
not with.
Yeah, I will resolve it. Just 2 minutes.
Sure. Now it is visible, sir.
Okay. And you can hear me also, na?
Yes, sir. Perfect.
Audio is okay, na?
Yes, yes, yes.
So we were there, yeah. It cannot be withdrawn. So table of contents. So definitions and interpretations of the terms that are used in the resolution plan. So you need to define all the terms which you want to define, because if a particular term is not defined, so it will have a meaning from the IBC or the regulation. Rather IBC only. There are from the definition section. The next thing is executive summary. Executive summary is very important because even for RP and even for COC, all the important things which are there in the resolution plan, if they are placed at one place in the form of executive summary, maybe a page or two, so that will be very helpful for them to take the decision. Brief about the corporate data from the information memorandum or from the website of CD or the information available in the public domain. So basically, brief about the corporate data means you should be able to understand that what the corporate debtor is, what the sector is to which he belongs, what are the causes of failure, and then it shows that you have taken an informed decision. So brief about corporate debtor is very important. And then next is overview of resolution applicant. Now, particularly, it should mention details as to since when it was established, the sector or the area of operation, all the statutory registration details, volume of activity, organizational structure. Basically, it should be giving details of the resolution applicant. Now, in one of my case where I have prepared the resolution plan, the promoter was a partnership firm dealing in basically construction as well as infrastructure projects, roads, and others. So he was basically a contract firm in building and other materials. So that entity was interested in acquiring castings unit. Now, what has helped me is his son has been an engineer and has gathered some management knowledge from US. So it was easy for me to show that why he want to diversify his business for a son. And that is how you need to give the background about the resolution applicant, which will convince the RP and COC. Next is the credit worthiness of or the financial ability of the resolution applicant. So for that, many a times it is better to give the net worth certificate of the company or the firm or the individual, which will show the credit worthiness or the financial ability of the resolution applicant. Now, prior experience of managing or turnaround of the company. Luckily, in one of my case, the resolution applicant who has successfully taken over one unit from IBC, a running unit, has got another opportunity of buying another unit. So if you have any such type of past experience, this will be an added advantage. Now you should also address to the key challenges and trends in the industry. The next is the note on turnaround. This note is important that if the earlier promoter or the entity has failed doing the business, how is it that you as a resolution applicant will turn around? So for that, you need to know the earlier weaknesses and then address to it that how you are going to turn around the business. Next is the financial plan. Financial plan or the financial feasibility is nothing but, like as I was giving you the example, that you need the book value might be something around 30 crores. And if you are getting it at 8 crores, so put it as 8 crores. And like we used to prepare the project finance spreadsheet showing the entire projected P&L, balance sheet, other working notes, means what you are going to buy, what you are going to sell, what are the prices. So it is now the project report type of calculations will form part of your resolution plan, which will show that the plan will be financially feasible. So that is how you need to work out under the financial plan. Next is important terms for implementation of plan. Here it should be remembered that there cannot be conditions, as a conditional plan is void ab initio and is not acceptable. So the important thing is you cannot mention such conditions, because conditional plan is never approved and is directly rejected. Similarly, next is the business plan. Business plan talks about the entire future, like what will be the marketing strategy, from where you are going to procure the raw material. So all these things and total business plan is to be explained. Then next is the implementation schedule. It should give the detailed plan of how the plan is going to be implemented. Means first, whatever money you are agreeing to pay, in how many months and in what way you are going to pay it. So that talks about the implementation schedule. And next is the mechanism regarding the management and control of the affairs of the company. So for that matter, you can say that many of the earlier employees who are significant will be retained, and that is how you will go with the mechanism of managing and controlling the affairs of the company in a better way. Manner of supervision and implementation of the plan. This requires that a monitoring committee be set up who will do this job. So as I told you that earlier, I was part of a monitoring committee in which there were 2 members who were appointed from the COC, and I was the third person appointed by the resolution applicant. So whatever decisions that were taken in the monitoring committee, that were in accordance with the plan that was submitted. So any deviation, the responsibility of the monitoring committee is to bring out the deviations, if any, to the notice of the adjudicating authority. Next is declaration that the plan is not in contravention of the provisions of any applicable law for the time being in force. Statement on how the interest of all the stakeholders has been taken care of. So that type of statements is also required to be given. Next is sources of funds from which the proposed payments shall be made. The next will be reliefs and concessions sought for. Those are to be specifically mentioned. Financial projections and assumptions, because these will be evaluated and questioned. So this has to be prepared in a proper way. And lastly, schedules as may be required for the RFRP document. So to conclude, basically, to sum up, once a resolution plan is approved by the Committee of Creditors under Section 30, subsection 4, and subsequently by the adjudicating authority by its order under Section 31(2), the resolution plan becomes binding on the CD and its employees, members, creditors, guarantors, and other stakeholders, including the central government, any state government, or any local authority to whom the statutory dues are owed. Section 238 of the code, having an overriding effect, stipulates that in case of any inconsistency between the provision of the code and other laws, the former shall prevail, which is augmented by the apex court in its various judgments as and when the priority of code was challenged. So section 238 is an overriding section. So it overrides all other acts for the time being in force. Similarly, one section 32A was introduced in the code, which came into effect from 28th of December 2019. This section gives immunity to the resolution applicant relating to the liability of a CD for an offense, maybe civil or criminal, committed prior to the commencement of the corporate insolvency resolution process. So this is all about the resolution plan. Now I will request the participants. Basically, I will be interested in taking questions because lot many things can be discussed. If you have certain things in mind, better we can have. Now, please open up your video and audio so that we can have a good interaction.
Sir, let us first take the query posted by the participant in the chat box. It is SR Still case, the promoters were not allowed to take over the company. Was it because they were the defaulter?
Yes, because there only the section 29A was tested, and they were the first victims of section 29A, where being a defaulter, they were not permitted to participate in the resolution plan. Otherwise, what will happen? It will be misused. Like the promoter himself will getting his own company at a discounted price under IBC, which is not the objective. मेरा ही business है और मैं बाकी लोगों को उसमें से concessions लेके and I am regaining the control. That is not permitted. That is not the objective.
Absolutely true, sir. Now the session is open. If anyone wants to ask directly a question, so they can. I guess no queries, sir.
See, basically, what I wanted to indicate is many of our professional friends, they might not be going in for practicing as an insolvency professional. I do agree, because I myself is not practicing in the area of GST, which almost came equivalently at the same time. But we need to know what is there in other laws, what are the opportunities. Without being an insolvency professional, whatever you can contribute, there are lot many opportunities available there in the insolvency space. So the important thing is all of us need to attend such type of seminars wherein at least something will be understood, because it is a new code. And with the help of that, we can try to participate in some of the activities wherein the direct participation of an IP is not required.
I completely second that, sir. Being a professional, one should have knowledge of each and everything. Since there is no more query, so I would like to, on behalf of Nagpur branch, I would like to express my deep sense of gratitude to Prasad sir for taking out time from their busy schedule and guiding all the members. And simultaneously, I thank you all the attendees for making this third session under the IBC series a successful one. Thank you one and thank you all. With respect to PPT, it will be get posted on the Nagpur ICI site within a week. So just stay tuned at nagpurici.org, and hereby I conclude this session. Thank you, sir.